So far we have discussed the concept of immediate indefeasibility of title. The next thing we're going to look at is the concept of the umbrella or the extent of indefeasibility of title. And why do we do that? Because understanding what is actually protected is fundamental in understanding what are the benefits of immediate indefeasibility of title. So in order to answer this question, what is protected, we need to think about what is actually included in the Torrens Register. Why would we bother? As I said, because what is included is what is protected by the Act of Registration. And what the High Court has told us is that anything notified on the register is what is protected. In order to understand this, we're going to have a look at this leading decision of the High Court in Bursell and Berger Brothers, which is still one of the leading cases in this area to this date. So what had happened in Bursell and Berger Brothers? Well, in this case, there were two adjoining blocks of land, and the certificate of title for each block referred to what was notified on the certificate of title was something called a right-of-way. The register, the Torrens Register, contained a transfer which included the terms, as you can see here, right-of-way as created and more fully set out in transfer number 7922, affecting parcels A and B. Okay, so when you looked at the certificate of title, if you're the conveyancing solicitor, you go through, you look at this certificate of title, and sitting in the second schedule for the certificate of title, or the Torrens folio, is a recording of an extension of a right-of-way. So the way the registrar had interpreted this dealing of the Torrens land was that this original transfer had created an easement burdening Bursell's land. When this matter comes up before the High Court doesn't agree with the registrar's interpretation of the rights created in the transfer as being only the creation of an easement, because the High Court says if you go and look at what that transfer number 7922 actually says, what you see is this: extension of existing road and grant all buildings at present erected on the said road or gateway, and the right to pull down such buildings and to rebuild others at the height of not less than 12 feet from the ground over such road. When the High Court looks at that document itself, which also makes its way onto the register, okay, so bear that in mind, the High Court says actually what that transfer is doing is creating a transfer entirely of the land, not the creation of an easement. And we're going to talk about the difference between easements and the transfer of exclusive occupation or possession of land at a later date. Okay, for now, all you need to know is what the High Court says is this is not just the creation of an easement. What this transfer actually did was create a complete transfer of part of the land, okay, part of the airspace in this case. Bursell argues that Berger could only hold those interests that had been created in the register and recorded on the certificate of title. And in this case, Bursell says that that only includes the thing that was notified in the second schedule, which Bursell says is only an easement, okay, not actually a recording of any conveyance. The High Court says, no, that's not correct, because the High Court says if the conveyancing solicitor, properly doing his job, had bothered to go and actually read what transfer number 7922 says, then he would have discovered there was also a complete transfer of part of the land. So what do we take from this case? Well, the High Court is saying to us, when you are the conveyancing solicitor or anyone dealing with the register, you can deal on the faith of the register. You don't have to go behind the register and investigate other interests, but you absolutely take subject to anything that has made its way onto the Torrens Register and you have notification of on a search of the register. Here, if you're the conveyancing solicitor, you would have gone in, you would have seen notified in the second schedule creation of this right-of-way, more fully set out in this transfer. At that point in time, you, solicitor, should have gone and checked what transfer number 7922 said. That made its way onto the Torrens Register. Nothing had expunged it at the point at which the conveyance was taking place. And the High Court says if the solicitor had gone off and checked the transfer, then he would have also discovered, this isn't just an easement. Actually, what it is a complete transfer of part of the land that my client wants to purchase as well. Okay. What we can take from this is that anything that is notified on the register is discoverable and actually becomes part of the Torrens folio. It's what gets the benefits of immediate indefeasibility at the moment of registration. So it actually becomes part of the features of the land at the moment of registration. And anyone transacting the property, in Torrens, the thing you've got to understand is you're transacting what is on the register. It correlates to something that is a physical space, but the register is absolutely everything.